News broke this morning that a High Court ruling has come down in favour of the government in relation to the £20 uplift given to universal credit claimants to help with pandemic lockdown costs not being given to people still on the old legacy benefit system as well. As many people will know, the government created universal credit as a means to combine several of the old legacy benefits, your jobseekers allowance, your ESA, your income support and so on, into one payment, allegedly in the name of simplifying the system. But in reality, creating a massive balls up that has blatantly become an exercise in reducing the incomes of the poorest and most vulnerable. Now, Mr. Justice Swift, the presiding judge, ruled that although extending the uplift to legacy benefits was discriminatory towards the disabled, that this was irrelevant because the point of the uplift was to help people in work whose incomes have been disrupted during lockdown. Now, for me, this doesn't wash. Not every universal credit claimant is in work. Some are looking for work. Some are choosing to move themselves from the legacy system over onto UC in the belief they'd be better off, rightly or wrongly. But the fact is, universal credit has been a calamity from the get-go. It has cost far more than it was ever intended to save, and if it had been structured correctly and competently, the legacy benefit system would have ceased to exist in 2017 when all claimants were supposed to have been automatically rolled onto it. That target's now been pushed back to 2024. It is no fault of legacy benefit claimants they have not elected to move themselves, not least because they'll be worse off, but they'll also go weeks without any money, whereas if they wait to be rolled onto it by the government, that's not the case. Those left on the legacy benefit system are disproportionately the most complex cases, those which universal credit is still not capable of administering properly, something many UC claimants will have experience of already with missed or incorrect payments commonplace. Now, we're talking the most disabled long-term sick people. There's 2.2 million of them. Now, because some disabled people will have elected to go on to UC voluntarily, there will be disabled people who got the uplift, yet people with the same disability on ESA, for example, will not have. This undermines the judge's ruling entirely, in my opinion. He acknowledged the discrimination, but dismissed it as irrelevant. How can that be when some disabled people not able to work will have got the uplift, but others won't, purely based on which benefit they get? This is very relevant, and I sincerely hope the claimants' lawyers agree and go forward to appeal, because I think there's still a case here and this judgment's a mistake. Also, don't forget the reason the DWP gave for uplifting legacy claimants had nothing to do with this. They blamed the computer systems. Life is hard enough on the disabled in Tory Britain, but this would have seen them handed £1,500 each, which on top of the real terms cut they've just had from the government, they could really do with.